Hello everyone, my name is Eric Fausner. I'm the Executive Online Editor for the Golden Gate University School of Law Law Review, and I'm sitting down today with student Tyler McKean on his paper on overcharging. Tyler, thanks for joining me today.
You're welcome, Eric.
First of all, I want you to talk a little bit about the class that you took, where you wrote this paper.
Well, the class I took was called Ethical Prosecutions, and we basically spoke about, or were taught about, the issues at large in criminal prosecution, where some attorneys or some prosecutors take advantage of the authority they're given. And as someone who wants to be a prosecutor, I took a lot of interest in that class, and I got a lot out of it.
So what in the class of ethical prosecutions inspired you to write about the practice of overcharging?
Well, in particular, I've noticed before I came to law school, or people just don't generally favor the government, or they don't have a positive belief in the government, or a belief at all, where sometimes prosecutors or law enforcement maybe don't place charges that are reflective of the crimes alleged. And the purpose of prosecutors, or at least my understanding was that they're supposed to uphold justice and find the truth of these things. And there was no finding truth if you're going to charge or make additional charges that do not actually exist.
That's a perfect segue. If you could, for the listening public out there that might not know what overcharging is, could you give a definition of it that everyone can understand?
Well, overcharging, I kind of touched on it already, basically is when the criminal prosecutor files charges that are not reflective of the crime, when there's insufficient evidence to attach itself to probable cause, which is a requirement for prosecutors to have when making the charges.
So, could you give us an example of a classic type of overcharging situation that you might come across in practice?
A classic example would be maybe somebody comes at another with a knife and from behind, and the prosecutor, maybe they'll go with maybe an assault and battery when there is generally not an assault because there's no impending fear of a battery.
So what would be the purpose of a prosecutor overcharging?
The purpose of a prosecutor overcharging would generally be to gain some leverage, possibly in plea bargaining, generally in plea bargaining, to get it down, because it is a common practice to plea bargain, because most cases do not go to trial, and most of the charges actually do get amended or taken out after the defendant has pled to certain charges.
I think a great example that you used in your paper is you framed the issue of overcharging on the case of Aaron Swartz, who was a young man at 26 years old who took his own life after being charged with numerous crimes. If you could please tell us a little bit about why you picked that case to frame your issue.
So Aaron Swartz was a student, I believe it was MIT, and he released several hundred or several thousand articles on the JSTOR archives, so it was free to access as opposed to being a paid service. And subsequently, he was charged by the district attorney in the local county, I think initially with 4 counts. One was breaking and entering, the others were some type of burglary. And after some proceedings, their charges were eventually dropped by the local prosecutor because the U.S. attorney would not turn over certain discovery that the defense attorney or that Aaron Swartz's counsel was requesting. So without that, there was no evidence to support their finding against Mr. Swartz, and the U.S. attorney proceeded, and they initially charged 6 counts against him, and those eventually multiplied to 13 based on different theories on the evidence. And eventually the pressure got to Mr. Swartz, and he succumbed to it, and he eventually committed suicide because the government was using its authority, or the U.S. attorney was using its authority to strong-arm him into a position they wanted him to be in.
Now, as I understand from what you wrote in your paper, when the U.S. Attorney's Office charged him with 13 different crimes, they carried almost 50 years of prison time.
Yes.
And the crime that he was actually guilty of doing was probably the original crimes he was charged with, which was breaking and entering and illegally accessing a computer, I believe.
Yeah, yes.
Which is a much lesser sentence.
Much lesser.
So would you say this is a case of classic overcharging?
This would be a case of classic example of overcharging.
You did actually talk about a lot of solutions to this problem in your paper that I thought were very interesting. So now I think we should go through each one of these one at a time. Now, your first recommendation was the use of a grand jury in charging cases.
Correct.
So how do you think this would safeguard individual rights from overcharging?
I think it would safeguard the individual rights from overcharging because while it does take the discretion or some discretion away from the prosecutor, I think having a grand jury where they have no interest in winning or losing would be a step in the right direction.
Another recommendation that you made that I thought was interesting and certainly probably controversial is your recommendation of the elimination in part of prosecutorial immunity. First, could you explain what prosecutorial immunity is, and then how eliminating that could prevent overcharging?
Essentially, the prosecutorial immunity would give way to or protects civil servants such as prosecutors from civil liability. So an example of this would be Connick v. Thompson. It was a case from New Orleans where Mr. Thompson was charged initially with murder. However, the prosecutor found, I think it was a swatch that was stained with blood, and there was actually also a robbery that happened around the same time, and due to the public pressure, they didn't test the blood, and they didn't get lab reports for the blood on the swatch, but instead they used it in his robbery case, got him convicted. And then in the murder case, he couldn't stand trial because they would just impeach him with that conviction. And by doing this, the attorney and Mr. Connick were protected with their immunity. And I know Mr. Thompson, I think, initially sued them for $14 million, and it was dismissed based on the immunity that Connick and the other attorneys that were involved had.
So is it your belief that if prosecutors know that they could potentially face civil liability for overcharging, that they'd be less inclined to do it?
I completely agree with that. I think my professor in business associations actually said this, particularly with officers and board members in associations when they have skin in the game, that it makes people think twice because they know something's going to happen if they mess up or if they do something that is unethical or wrong.
Now, your next recommendation I thought was also interesting, what you called vertical review. And the way that I understood it was that if a junior prosecutor wants to bring a certain charge, before they could do that, it would have to go up the ladder to a more senior prosecutor to review to make sure that there is probable cause to charge for a crime. Did I understand that correctly?
Yeah, that's basically the gist of it.
And how do you think that this sort of vertical review would help eliminate or reduce the risk of overcharging?
Well, I think what it helps to do to eliminate overcharging would be that it allows someone who's familiar with charging, or more familiar than, I guess, maybe a first-year, second-year prosecutor, and refer that up to a more senior attorney, that if they're on the right track to determining what probable cause is and if it actually exists, based on the facts presented to them on the police report or whatever reports they may receive. I actually have seen this in practice in my experience of working for district attorneys, and I think it's a very good not only exercise, but way of doing things. It does slow things down a bit, but I think having two sets of eyes, two brains, or multiple people looking at things who are in it for one thing, which is upholding justice and finding the truth, is a much better thing rather than having the sole discretion of one person who could potentially go rogue or have a bias towards certain types of crimes or people.
I thought it was an interesting idea. One question that it brought to my mind, though, is prosecutors' offices are notoriously overburdened with caseloads. There's more than most prosecutors can handle. How do you think it would affect prosecutors' ability to do their job if more senior prosecutors had to look at charging decisions made for misdemeanors, petty theft, drug crimes, those sorts of things? Do you think that it's more trouble than it's worth to do?
Ultimately, the cost of it in terms of time would be outweighed by the fact that, and while there is a very minimal case of prosecutors being found of overcharging and violating these ethical rules, I think the ultimate idea is to eliminate it in general, and I think that is what that outweighs the cost of time, of everybody's time, where finding the truth, seeking justice, and doing everything right because the prosecutor represents, I guess, the king or the government, and the people need to trust the government, and unfortunately that trust isn't there.
Now I want to go to something a little lighter, not as intense as it's like locking innocent people away, but takeaways from the class, things that you liked about the class with Professor Cambry, and recommendations, of course, to future students that might be interested in taking the class.
Okay, well, as somebody who wants to be a prosecutor, I took a lot of interest in it because Professor Cambry herself was a prosecutor who worked in multiple jurisdictions. She worked in New Orleans, she also worked in New York, and having her point of view on the class really made you think about things because you don't see them like that in real life. When you're in practice as a law clerk at a district attorney's office, you don't understand a lot of things that go into it because you're so limited in what you can do. You can't file charges. And when she actually had an exercise for us, she's like, well, would you file this? And it was actually much more difficult than than most people would think. People think, oh, probable cause, supported by case law. I know what that is. It's actually very difficult to determine, and that was my biggest takeaway from the class. And then she also harped on, and something I really appreciated was that it is a very important job, and it's not for everybody, and people need to be aware of the consequences, and you need to do it honestly and ethically and morally, even though sometimes you will maybe have to do something to uphold your morals, even though it may be ethical to do it, and even though the ethical way of doing it may be wrong. And I found that to be very interesting as well. For future students, I think it's an excellent class. I learned a lot from the class, and I took a lot of it into my 3L summer, because I finished that my second year of law school.
Well, thank you very much for meeting with me today, Tyler. Very excited to have your paper published very soon, and I'm sure it's going to start a great conversation out there in the legal community, and we look forward to your comments. Thank you.